Ladies and gentlemen, welcome to today's program titled What You Need to Know About the Proposed Stark Law and Anti-Kickback Statute Regulations. At this time, all participants are in a listen-only mode. For those of you who are logged into the webinar presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen and press Enter. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be repeated, and it is required for CLE credit. Copies of the webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Leon Rodriguez. You may begin.
Good afternoon. This is Leon Rodriguez. I'm a partner in the Washington, D.C. office of Seyfarth Shaw. And it's our pleasure this afternoon to talk to you about some recent and very significant changes in the Stark law and Anti-Kickback Statute regulations. Today, you'll be hearing from two of my partners, Bill Eck, who's here in the Washington, D.C. office with me. He is a healthcare and a very experienced healthcare lawyer specializing in mergers and acquisitions and sales and strategic affiliations, with a focus in particular on many of the regulatory issues that arise in those cases. We're also joined by our partner, Chris DeMeo, based in Houston, and he too is an extremely experienced healthcare lawyer with focus on healthcare fraud and abuse, patient information privacy, licensing and reimbursement, just to name a few areas of his expertise. Today we're going to be talking to you about regulations that are part of the so-called regulatory sprint to coordinated care. And as you look at the slide deck and see our pace going through our presentation today, you'll feel like you too are on a sprint. We're going to cover a lot of ground in the hour to come. We're going to be talking very quickly about some background, both as to an overview of the Stark and Anti-Kickback statutes, and then a couple of concepts that are going to overarch the entire presentation today. We're then going to talk about the proposed Stark regulations, the proposed Anti-Kickback Statute regulations, and then I'll speak very briefly about implications. Background and overview. Many of you will already be familiar with the Stark statute, which is found at 42 U.S.C. section 1395 NN. This imposes strict liability for physicians who refer Medicare patients for designated health services to entities in which they have a financial interest. Often this is actionable under the False Claims Act. Also, and similarly, we'll be talking about the Anti-Kickback Statute, which establishes actually a criminal offense for knowingly and willfully offering, paying, and soliciting or receiving any remuneration to induce or reward referrals of items or services reimbursable by a federal health care program. That, too, is often actionable under the False Claims Act. One particular concept about which you'll be hearing a lot, and which is very much one of the stars of the new Stark and AKS regulations, is the idea of value-based arrangements in healthcare. And so to get us going, I'm going to ask Bill Eck to give us an overview of what do we mean when we say a value-based arrangement.
Well, value-based arrangements are primarily large networks like PHOs or risk-bearing IPAs or the like, which include hospitals and physicians and other types of providers and bear risk and contract with health maintenance organizations. Although under the regs, the proposed regs, that is, they can be as small as groups of 2 physicians. So I think the regs are mostly aimed at large organizations, but they can be smaller organizations And they can be disease-specific organizations, organizations that focus on chronic diseases like arthritis or joint replacement or things like that.
Chris, I have a question for you. Can you talk about how the value-based safe harbors might affect the current managed care environment and accountable care organizations?
Sure. So there are a lot of providers and networks that got involved several years ago in the Medicare Shared Savings Program, and some, with good success. Some are on a path to success. These new safe harbors are a way for those existing networks or an IPA or PHO, other managed care expressions, to have an opportunity to maybe restructure their current arrangement, allow for a freer flow of benefits, sometimes monetary, sometimes in kind, and the new safe harbors allow an opportunity to say, our current arrangement is structured in this way, maybe we can redesign it to take advantage of these safe harbors.
And, some providers might have some concern or might not necessarily be as well positioned to take advantage of the new value-based safe harbors. Or how will independent providers and rural providers fare in the value-based environment?
So that there is some concern on that specifically, and in the comments that have been submitted, independent practice associations have voiced concern, and the OIG itself has expressed some concern in the preamble about consolidation in healthcare, and so rural providers as well are concerned that they may be further marginalized and not be a part of these networks. What, at least on the Anti-Kickback Statute side, is being done to address that is to provide certain waivers in the rural context for independent providers. Like Bill said, I mean, you can be as few as 2 and be considered value-based. However, maintaining independence is going to be a struggle moving forward, and that's, I think, recognized across the board.
And I think in the area of full risk or meaningful downside risk, the amount of services that need to be covered from a payer standpoint will have an adverse impact on the regulations as proposed. That is, will have an adverse impact on rural or smaller networks and providers. So I think that's something that will need to be addressed in the final regulations to provide some relief.
Great. So, Bill, I'm going to turn over the slide deck to you now and take us through the new Stark regulations.
Okay. Well, first I wanted to just mention, as Leon said, the Stark law imposes liability where there are financial relationships and referrals for designated health services. And just very quickly, DHS are clinical lab services, PT, OT, radiology, radiation therapy, DME, enteral, parenteral, prosthetics, orthotics, home health, outpatient prescription drugs. Most significantly, for purposes of what we're talking about today, I think they include inpatient and outpatient hospital services, but they also include speech-language pathology services. The biggest exposure under Stark is the False Claims Act liability, where there's liability for triple damages plus over $25,000 per claim. There have been numerous judgments that have had a chilling effect. For example, the Halifax and the Halifax judgment is one of them, and the Toomey judgment I was looking for, which have had a chilling effect on relationships between hospitals and particularly surgeons and compensation there. And those are areas which CMS has endeavored to address in the proposed rule. So in response to some of these concerns, and to foster the regulatory sprint to coordinated care, which Leon has already mentioned. CMS has made the most sweeping changes in almost a couple of decades to the Stark regulations, and they fall into three major areas. The first is establishing new exceptions for value-based enterprises, and value-based arrangements. Think here, as we've already mentioned, ACOs, risk-bearing, PHOs and IPAs, and other forms of networks that contract with managed care organizations. The second area would be updating and modernizing key concepts under the existing exceptions. One would be the concept of commercially reasonable. Two would be the relationship of compensation to the notion of independence from the volume or value of referrals. Three would be updating the concept of fair market value and compensation arrangements. And the third area is the adoption of new technology and encouraging the adoption of new technology. So the first, we have three exceptions for value-based arrangements, and the first one is for arrangements that are at full financial risk. Before I get into that, there are a couple of key definitions to keep in mind, and Chris will deal with these in a little more detail under the AKS exceptions for value-based arrangements. But just to touch on a couple of them to provide some orientation, there's a value-based enterprise, which is the network organization itself, and that includes, according to CMS in the proposed regulations, two or more value-based participants which collaborate to achieve at least one value-based purpose. Each of these has to be a party to a value-based arrangement with the other, or at least one other VBE participant in the value-based enterprise. It has an accountable body or other person responsible for financial and operational oversight. It has a governing document that describes the VBE and how the VBE participants intend to achieve the value-based purpose. And that's a value-based enterprise. The value-based purpose is coordinating and managing the care of a target population, or improving the quality of care of a target population, or reducing the cost of growth, or reducing the cost of or growth in expenditures of payers without reducing the quality of care for a target population. Or it could be transitioning from mechanisms based on volume to mechanisms based on quality of care and cost control. And a VBE participant is a provider or individual or entity that engages in at least one value-based activity as part of a value-based enterprise. And a target patient population is an identified patient population that's served by this value-based enterprise, and it's selected based on legitimate and verifiable criteria set out in advance of the value-based arrangement. And here we have some commentary in the proposed regulation and the comments to the proposed regulation around the phrase legitimate and verifiable criteria. That's an awfully vague notion, and given the penalty exposures under the Stark law, there's hope that CMS will engage in more precision and clarity in the criteria that it promulgates with the final regulations. So moving on to the exceptions themselves, we have three value-based exceptions. The first is for organizations that are at full financial risk. This applies to value-based arrangements that are fully financially responsible on a prospective basis for the cost of all inpatient care items and services that are covered by the applicable payer for each patient in a target population for a specified period of time. The regulations provide for a 6-month ramp-up, so you don't have to be fully financially responsible until after a 6-month period. But here, I'll draw your attention to the fact that you have to be responsible for the cost of items and services covered by the payer, not offered by the network. So the network has to be responsible for out-of-network items and services, and that's something that drew a lot of adverse commentary to the proposed regulations, and we'll see if CMS addresses that at all in the final regulations. The remuneration is for results from value-based activities undertaken by the recipient of the remuneration. The remuneration is not an inducement to reduce or limit medically necessary items or services. The remuneration is not conditioned on outside referrals. If the remuneration is conditioned on referrals to a particular provider, practitioner, or supplier, it satisfies the general requirements for such referrals. So there, as an example, that would be like the requirements that apply typically today to HMO referrals, in-network HMO referrals. The second exception is the exception for meaningful downside financial risk to the physician. Let me advance the slide here. That applies to value-based arrangement where the physician is responsible to pay the entity for not less than 25% of the value the physician receives under the value-based arrangement, or is financially responsible to the entity on a prospective basis for the cost of all or a defined set of patient care items and services covered by the payer for each patient in a target population for a specified period of time. The physician is at meaningful downside for the financial risk for failure to achieve the value-based purposes of the enterprise during the entire duration of the value-based arrangement. Now here there was a lot of commentary directed around the 25% requirement and to the effect that 25% was just too high, and to the effect that the 25% should be lowered in the final regulation. So we'll see if CMS gives any relief to that or if we're stuck with 25%. And the basis of the commentary was that 25% was too high to make it usable by physicians in value-based arrangements. And next, there's a requirement that the description of the nature and extent of the physician's downside risk is set forth in writing. The methodology and the amount to use to determine the amount of the remuneration is set forth in advance of the undertaking. The remuneration is for or results from value-based activities undertaken by the recipient of the remuneration. It's not an inducement to reduce or limit medically necessary items or services. It's not conditioned on outside referrals. If it's paid to a physician, conditioned on physician's referrals to a particular provider, practitioner, or supplier, it satisfies the general requirements that apply to those referrals. And think there again about general HMO referrals. And then lastly, we have the physician, we have the referral, the exception for value-based arrangements. Now, these don't involve any downside financial risk. So there's a series of requirements that are somewhat formalistic, but I'll just run through them quickly. They require that value-based activities, a written description of value-based activities, a description of how those activities are expected to further the value-based purposes, a description of the target patient population, a description of the nature of the remuneration, of the methodology used to determine the remuneration, of the performance or quality standards against which the recipient will be measured, and advance the slide, a description of the methodology used to determine the amount of the remuneration, and if the remuneration is for or results from value-based activities under the recipient of the remuneration for patients in the target population, the remuneration is not an incentive to reduce or limit medically necessary services. The remuneration is not conditioned on outside referrals. If the remuneration is paid to the physician conditioned on referrals to a particular provider, practitioner, or supplier, it satisfies the general requirements applicable to such remuneration. So that takes care of the value-based exceptions, and we move on to exceptions that update and modernize the existing Stark exceptions, and here we move on to the big three. And these are intended to make the existing regulations more useful to providers and practitioners. So first is the one to reinterpret commercially reasonable. And I don't think this makes a big difference, but it interprets commercially reasonable to make a particular arrangement commercially reasonable if it furthers the legitimate purpose of the parties and is on similar terms and conditions as like arrangements. Second, it's commercially reasonable if it makes commercial sense and is entered into by a reasonable entity of similar type and size into a reasonable physician of similar scope and specialty. Now, one thing that is different here is that it introduced the concept of a reasonable physician, and that wasn't part of the regulation before. And lastly, for the first time, CMS expressly states that an arrangement may be commercially reasonable even if it does not result in profit for one or more of the parties. So next we got into a proposed regulation that reinterprets fair market value. Now their CMS was somewhat constrained because there's a statutory definition of fair market value. So CMS was constrained by that definition to say that fair market value is with like parties under like circumstances, like assets or services, consistent with general fair market value, and in the context of rentals, with fair market value under like circumstances of rental property for general commercial circumstances consistent with the general market value of the subject transaction. And I think query whether that really changes anything. I think in the past, the touchstone for this has been what GCal or one of their competitors would charge for a piece of rental equipment, and I don't think this really changes that to any great extent. And I question whether this definition really changes it. For rental of office space, there's another proposed regulation in the area of fair market value. It changes it to with like parties under like circumstances of rental of property for general commercial purposes without adjustment to take into effect the additional value to the lessee or lessor based on convenience where there's a potential source of referrals and consistent with the general market value of the subject transaction. The proximity or convenience for the source of referrals, I think, doesn't change it from what already existed in the regulations or statute. But here we got to an important one, which is the changes to the volume or value standard. Here there was a lot of opacity, and it led to some significant judgments and settlements under the False Claims Act. And what CMS endeavored to do is create some bright line rules. So what CMS really did here was to create, first of all, clarify that other business generated meant other business generated by the physician for the entity and not vice versa. And then it went on to say that a compensation from an entity furnishing DHS, like a hospital, to a physician, think a surgeon, takes into account referrals only if the formula used to calculate the compensation includes the physician's referrals as a variable, resulting in compensation that positively correlates with the number or value of the physician's referrals. And think there that the compensation for DHS, like the technical component of surgery, would include compensation to the physician, and if it doesn't include that positive correlation, then the compensation doesn't depend on the volume or value of the physician's referrals for the DHS. And secondly, there's a predetermined direct correlation between the physician's prior referrals for DHS to the entity and the prospective rate of compensation to be paid over the entire duration of the arrangement for which the compensation is determined. This is only to cover the situation where prior DHS referrals are used to compensate for present or future compensation. And next, this is just to make it to do the same thing with taking into account other business generated for the entity. So next, it takes care of compensation from the entity to an entity furnishing, compensation from a physician to an entity furnishing DHS. And it says that the formula used to calculate the entity's compensation includes the physician's referrals to the entity as a variable, resulting in a decrease or increase in the entity's compensation that negatively correlates with the number or value of the physician's referrals to the entity. So here what I would think of as a laboratory where the physician's Medicare referrals to the laboratory drive the rate of compensation of the physician to the laboratory for other referrals. And once again, you have the corollary, which makes prior referrals of Medicare business as a basis for future compensation for non-Medicare business. And the same thing goes for business otherwise generated. And lastly, CMS updated the cybersecurity technology and related services safe harbors, implementing a safe harbor, or not implementing, but proposing a safe harbor for cybersecurity technology and related services. There's a non-monetary remuneration consisting of certain types of cyber software technology and services if the technology is necessary and used primarily to implement or reestablish, maintain cybersecurity. The eligibility, et cetera, is not related to the volume or value of referrals or business otherwise generated. Physician or physician's practice does not make the receipt of the technology a condition of doing business with the donor. The arrangement is documented in writing. Cybersecurity means protecting information by preventing, detecting, and responding to cyber attacks. Technology means software or other types of information technology or other than hardware. Now, a lot of the commentary to the proposed regulation wanted hardware included, but if CMS does that, you know there's going to be a financial cap on that. So I would be skeptical whether CMS would do that, but we'll see if they do. If they do, I think there will be a financial cap on it. And lastly, CMS updated the EHR changes to the Stark exception by permitting the donation of cybersecurity software and services, taking out the sunset provision, aligning it with the 20th Century Cures Act, and entertaining in the preamble other considerations like removing the 15% contribution requirement and permitting donation of certain replacement EHR technology. Right now, that's only in the preamble, but I would expect to see something like that in the final rule, especially considering what it said in the AKS rule. So with that, I'll turn it back to Mr. Rodriguez.
Great, thank you, Bill. Covered a really incredible amount of ground in a very short time. Before I turn over to Chris, I want to share the continuing legal education code with everyone. That is S as in Sam, 2310. Once again, S as in Sam, Sam, 2310. And with that, I turn over to Chris DeMeo to talk about some anti-kickback changes.
Thanks, Leon. The Anti-Kickback Statute safe harbors underwent similar changes as the Stark Law exceptions that Bill was just telling us about. But it would be a mistake to assume that all the changes are exactly the same. The Anti-Kickback Statute and Stark are different laws targeting different activities, albeit with substantial overlap, but with different consequences. These differences are reflected in how the OIG, the Office of Inspector General, addressed the concepts of value-based and the general loosening of the regulatory restrictions. And I'll highlight as much as I can the changes, because there are a significant amount of similarities, but there are differences as well. Now, the anti-kickback portion is going to be covering 3 parts. We are going to discuss the value-based entity safe harbors that are new. We are going to address changes to existing safe harbors, and then we are going to address very briefly some new non-value-based safe harbors. So with the spirit of the regulatory sprint in mind, let's get rocking here. Some key concepts that we did discuss at the beginning for value-based, but that have a different wrinkle for the OIG and the Anti-Kickback Statute are listed here. Value-based currently does not have an official legal definition. It is a we know it when we see it type thing, but it does need to be directed to care coordination, improved outcomes, efficiencies, and reducing cost. And so it is what you would expect, but there's no formal definition now, although the OIG is anticipating perhaps coming out with one. There does need to be infrastructure, and Bill spoke to that in the value-based entity. I'll speak some more to that as we go forward. There are risk-bearing payer agreements that are at issue throughout the value-based safe harbors that express themselves in different ways. And there are evidence-based outcome measures, which is a particular facet to the OIG regulations that are not as present in the Stark revised regulations that must be demonstrated or at least pursued by the recipient of the financial benefits in order for the safe harbor to be effective. And so moving forward to some key terms, the value-based purpose and enterprise are very similar to what Bill discussed under the Anti-Kickback Statute. As for the Stark Law, I'll draw your attention to the value-based enterprise. The OIG says that a value-based enterprise does not need to be a distinct legal entity, but given some of the requirements in having contracts and risk payment arrangements, I don't see how that could be possible on a large scale. Importantly, for the Anti-Kickback Statute, a value-based enterprise excludes pharmaceutical manufacturers, durable medical equipment, prosthetic and orthotic suppliers, and labs. The OIG is also anticipating perhaps excluding pharmacies, pharmacy benefit managers, and device manufacturers from those entities that can be in a VBE. A note on the format here, you'll see a question mark in parentheses throughout the anti-kickback slides. That designates an item that the OIG is considering now. They are not in the proposed regulations, but may be included in the final regulations, depending on the comments. Target patient population, again, very similar to what Bill described. The OIG is considering limiting the target patient population to those of chronic conditions only. There's been significant pushback on this concept in the comments across industry sectors. There has also been some concern on patient choice that has been voiced in this TPP concept, being that the patient may not know how they got into the TPP or who their providers are, and there's not an easy access opt-out provision. It's an affirmative opt-out opportunity, which we'll see in some of these safe harbors, but it is not something that is addressed to the patient on the front end. More key terms, I direct your attention to the middle value-based arrangement. That is the backbone of all of the safe harbors. This is the arrangement through which the financial benefits will flow, largely in-kind type benefits, but also money payments can flow through the value-based arrangement, and they need to meet the certain criteria that are discussed and defined in the regulations. And at a high level, they can be between participants in the value-based entity, but more often than not, for safe harbor protection, we're talking about arrangements between the entity itself and the participants. A participant can be a provider, a payer, or a non-provider company. And we noted the exclusions in the prior slide, which are, again, specific to the Anti-Kickback Statute rules. The first safe harbor is at EE, which is an indication of how many safe harbors there are. We've passed through the first 26 and are headed towards more. It is a care coordination arrangement safe harbor. Importantly, care coordination, as you may have noted from the prior slide, is a defined value-based purpose, and it must be present in each of the safe harbors. This is another specific difference in the Anti-Kickback Statute regulations, that each safe harbor must include care coordination and management. They may include other value-based purposes, but care coordination and management must be present in all of them. That has been the topic of many comments, again, across industry sectors, asking for more flexibility in line with the Stark regulations and not so tied to care coordination. There is no risk-based contract that is required for this safe harbor, but there are 11 separate criteria, each with their own sub-criteria to be followed. And from the most sophisticated healthcare systems down to the independent associations who have weighed in on this safe harbor, there has been concern for the denseness and the burden in having these many criteria in order to get the benefit of the safe harbor, and a call to maybe reduce some of these. I call your attention to the middle of the slide. It protects in-kind remuneration only. That can be services, that can be items and infrastructure, but no gift cards and no opportunity for participation in the ownership of the value-based entity. I also call your attention to the requirement for the recipient to pay 15% of the offeror's cost in order to qualify for the safe harbor. So the way this could play out is you have a managed care setup. It qualifies as a value-based entity. It provides scribes to physicians to follow them around, to do the documentation, so there's uniformity and efficiency in getting items into the EHR. That can be provided as an employee of the value-based entity, and the physician would have to pay 15% of that cost. What that means as far as the cost is devil in the details moment that we will see throughout these proposed regulations. I will also call your attention to the bottom of the slide, the citation there, 84 Federal Register. That page range is an example of what the OIG believes is a legitimate arrangement under this safe harbor. Potential additional safeguards, having an accountable body that monitors the evidence-based outcome measure that the recipient must comply with, having a fair market value requirement for the remuneration, which has received significant blowback across industries, and that was part of the point to go through these overhaul of sorts, is to get past some of these fair market valuation requirements. Yet still, that could be a part of the final regulation. The OIG went out of its way to discuss additional potential safeguards for dialysis providers, and I note that here because it ties in what we mentioned at the beginning of the presentation. These care coordination safe harbors are moving toward a consolidation. That could be one way to achieve it, and the OIG noted the significant amount of consolidation already in the dialysis industry and how that could harm patient access. And so that concern could be expressed in other areas as well to protect some independent providers. But there may be additional protections in the dialysis area, and as comments have been digested, there may be some other protections as well. An alternative is just to add this care coordination safe harbor onto the existing personal service arrangement safe harbor. Substantial downside financial risk is the second of the value-based safe harbors, and substantial downside risk is defined. There are specific examples, one of which being a 40% loss sharing in a Medicare ACO shared savings program contract. In addition to the VBE itself assuming financial risk in order to get the benefit of the safe harbor, the recipient of the financial benefit must meaningfully share in that downside risk. Meaningfully share is also defined in the regulations, and for example, it could be a capitation arrangement. For physicians who receive the benefit of this safe harbor, it could be following the substantial financial risk Stark exception. And so there has to be shared risk by the recipient in order to get the benefit of the safe harbor. So the safe harbor protects in-kind and monetary arrangements. So the recipient can receive infrastructure, can receive services like a scribe, a patient care coordinator, can receive communications infrastructure, can receive monetary bonuses if the requirements are met. The payment must go towards activities, however, and this is not specifically articulated in the slide, but must go towards activities that are directly connected to the assumed risk, and that's important as we move on to full side risk. There are other requirements in the safe harbor which you might expect. There needs to be a writing. The remuneration cannot be based on volume or value of referrals of business. And then potential additional safeguards for commercial reasonableness, a bona fide determination of the value-based arrangement. Full financial risk, a word here is that the recipient of the benefit does not have to share meaningfully, as in the substantial downside risk, and there is no express requirement in the regulations that the activities for which payment is received have to go towards the risk assumed. And so while, as Bill mentioned, you have to assume the risk for the entire patient population of the payer, if one of those contracts is in place at the VBE level, there is nothing in the regulations at this time to prevent that value-based enterprise from using this safe harbor for services to other patient populations. So for example, if you have a Medicare Advantage HMO, there is nothing in the regulations that prevents this safe harbor from being used for VBE participants that serve commercial-based patients. So I don't know whether that's the intent, but that is how the regulation is written now. Patient engagement and support is another new safe harbor that is value-based. You'll see that it is limited to in-kind remuneration, and then there's a $500 per patient per year limit. Both of those are up for consideration depending on comments. And there is a new value-based safe harbor for model arrangements for those of you that are already participating in a CMS-sponsored arrangement. For existing safe harbors that have seen revisions, the personal services arrangement is one of the most ubiquitous safe harbors in dealing with service arrangements. You'll see in the first bullet how it can cover anything from a medical director to a management agreement to a billing arrangement. It is utilized in a variety of different circumstances. There are two proposed changes and one proposed addition, and let's discuss those now. The first proposed change is to transition the requirement that the payments be set in advance to that the methodology for payments be set in advance, and that is important for this reason. Currently, to qualify for this safe harbor, the payments over the course of the arrangement must be set in advance, meaning you have to know exactly how much you're going to pay over the course of a year or more. That basically boxes out hourly arrangements, percentage of revenue arrangements, or RVU arrangements, because you do not know how much the individual or entity is going to earn over the course of the contract. Now only the methodology need be set in advance. And so if you have a contract that says the provider will be paid X amount per RVU or X amount per hour, that gets you safe harbor protection. This brings the safe harbor in line with the Stark exception. Remains to be seen whether OIG will follow CMS in interpretation of this new facet to the law. Non-full-time arrangements under the current law require that every element of time spent and the compensation for that time spent be set out specifically in the contract, which again makes some of these call coverage arrangements, for example, medical director arrangements, virtually impossible to fit into the safe harbor. OIG is proposed to eliminate that requirement entirely, which greatly opens up the scope of the safe harbor. Outcome-based payments is the new element to the safe harbor and awards payments or protects payments rather that are listed there under that criteria. There are outcome measures, as you see near the end of the slide, that are required to be followed. Evidence-based outcome measures are also a critical part of the value-based arrangement safe harbor in that they must be present for safe harbor protection, and they must be monitored. For this safe harbor under the personal service arrangement provision, however, they must be achieved in order for payment to be protected. And so, again, this is a nuance to the Anti-Kickback Statute regulations that is not present in the Stark Law regulations and could greatly, according to almost every commenter who's touched on this issue, restrict the applicability of this safe harbor. In addition, the OIG did, in the preamble, outline specific examples of what an outcome-based payment could be: shared savings, gain sharing, bundled payments, so things that you are generally familiar with, no surprises there. There are elements that relate to patient choice and protection of patient choice. As I mentioned before, whether those will in practice really protect patient choice or whether they will simply be there if a patient is savvy enough to understand protecting their choice of provider remains to be seen. In this safe harbor, as in all of the anti-kickback safe harbors that we've been discussing, there cannot be any remuneration that induces a reduction of care. And as you see near the bottom of this slide, pharmaceutical manufacturers, DMEPOS, and laboratory are excluded from participation. And as you might expect, those interest groups are objecting to that provision. Warranties have been, the safe harbor has been revised to allow for bundled warranties, which makes sense if you are in a care coordination environment. Having a suite of services and products protected is beneficial. It also protects related services, i.e. customer service and repair can also be warranted. There can be no requirements, however, of exclusive use or minimum buy-ins in order to trigger the warranty if you want safe harbor protection. The electronic health record safe harbor has also been updated. Similar to the Stark Law, the sunset provision has been removed. There have been some slight changes to the definitions under the safe harbor to EHR and to interoperable. According to OIG, these are not supposed to be substantive, but merely a recognition of how technology has advanced and to bring the Anti-Kickback Statute safe harbors more in line with the 21st Century Cures Act, which is cited there if you're not already familiar with that. As with the Stark revision to EHR, there is consideration of limiting the 15% contribution requirement for this safe harbor, and of course that has been welcomed with open arms. The free local transportation safe harbor has also been revised. You can see that the distances have been updated, but most intriguing, I think, is the consideration here in the final rule to include non-healthcare activities as a basis for the transportation, whether that be a trip to the store to get a healthy diet, et cetera, to bring in line with social determinants of health focus that is very prevalent in most healthcare looking forward today. Cybersecurity, Safe Harbor is new, very similar to Stark. Hardware is not allowed. Note, however, that there is no contribution requirement. And cybersecurity is a very hot topic. The one commenter in particular said that it is so important that the OIG should not even worry about fraud and abuse. There should be no limitations at all on cybersecurity because it is that important. With that, I move to the last of the new safe harbors, which is for ACOs. It basically codifies in the regulations the 1128B 3K from the ACO program statute. And so, Leon, I turn it over to you. Who may be muted?
Sure are. Thanks, Chris. To draw us to a close and to wrap up the presentation, we see in these exceptions, we see HHS really trying to promote particular directions for healthcare. So we're looking at the value-based exception, the goal of care coordination, and everything that goes with that, consolidation versus clinical integration, advancing antitrust objectives, leveraging data and the electronic health record, but at the same time protecting the privacy and security of information. On the operations side, you see a real effort by HHS to review current arrangements to remove remnants of old law. And even in the prosecution context, turning now to how all this gets enforced, you've seen some parallel changes to eliminate some of the more vexing aspects of how anti-fraud enforcement worked in the past. And so you have the Granston memo, which empowers DOJ to move to dismiss quitoms in which DOJ is not intervening and thinks lacks merit. And importantly, you have the Brand memo that breaks really important new ground by saying that you can't base any kind of enforcement action, prosecution, not just in healthcare, but in other regulatory areas, purely based on guidance. There needs to be a violation of actual law, whether it's regulation or statute is the foundation for prosecutions. And similarly, you have new commercial reasonableness standards under Stark, which similarly really represent a sincere and authentic effort to bring both Stark and anti-kickback statutes in line with commercial reality. Having said that, though, the fact is that enforcement still is very much alive and active. So if you take a look at the 2018 Healthcare Fraud and Abuse Control Program report, you'll see recoveries well north of $2 billion in all kinds of areas, many cases involving anti-kickback statute allegations in the long-term care environment, the DME environment, labs, hospital and health systems. In general, the exposure for healthcare entities really continues, notwithstanding all of these really very important and very positive changes that Chris and Bill discussed today. So with that, we have about 6 minutes left before the top of the hour, and I'm going to turn back to Sandra to open us up for questions.
Thank you very much, gentlemen. And ladies and gentlemen, at this time, we will conduct the question and answer session. And as a reminder, to ask a question via the web presentation, just type your question into the text box on your screen and press enter. And back to you, Leon.
So, Leon, this is Chris. I just, while we're waiting on a question, I wanted to touch on something that you mentioned in the implications. An interesting irony, as I saw it, you mentioned the Brand memo and how prosecutions, shouldn't be based on regulatory guidance. Well, as mentioned by Bill in the opening about Stark, there have been significant recent cases that have come down on some physician-hospital arrangements based on commercial reasonableness. And in the preamble to the new Stark regulations, the CMS basically came out and said they disagreed with those decisions. And so here we have a sub-regulatory guidance, which is actually helpful, that now we're, but on the same hand, we're trying to diminish the importance of that sub-regulatory guidance. And so I thought that was an interesting irony in prosecutions moving forward. But hopefully you're right. It is more of a realistic perspective on how hospitals and physicians and other healthcare providers contract to do business that can be safe from unnecessary regulatory enforcement.
Thanks, Chris. I know there was a question before about whether participants today will have access to the audio, and in fact, we will be emailing links to all registrants to the audio, to the full slide deck, which actually includes quite a bit, considerably more content that Bill and Chris developed, as well as answers to Q&A questions that we were not able to cover during the course of this presentation. As you look at these changes, and a question really for both Bill and Chris, as you look at these changes, what do you see as the biggest risks for providers trying to take advantage of these changes? Where do you think things might go wrong for them?
I think one area of significant risk is that in the reformation of exceptions, of existing Stark exceptions, providers will overinterpret the degree of CMS making the exceptions more friendly to providers. And for example, in the changes to fair market value and commercial reasonableness will overinterpret those changes as becoming more friendly to providers, whereas I don't think that they're really as friendly to providers as some might think in reading the preamble to the regulations. And I think interpretation and enforcement by the courts will bear that out.
One thing that I believe can be a risk on the value-based safe harbor side is this was on the slide for care coordination arrangements, the safe harbor that does not require financial risk. There is a provision that the arrangement has to be terminated within 60 days under certain circumstances. And that could be problematic if you are donating the types of infrastructure, phone lines, could be EHR, that may not fit exactly within the EHR safe harbor. It could be personnel, office space, et cetera, that a 60-day out may not give sufficient time to unwind. And so, some value-based entities that do go all in with to take advantage of some of these in-kind donations, may find themselves scrambling to unwind it if one of these triggers for termination is tripped.
So I think we're just about at the top of the hour. Let me one more time repeat the CLE code, and that is S as in Sam, 2310. Once again, S as in Sam, 2310. I want to once again thank everybody for joining us today. We're going to look forward to sharing the full slide deck with you, the recording of today's audio, as well as answers to a couple of questions that we were not able to cover during the course of this presentation. Thank you all. I think it's afternoon for most, but not all of you, so have a great day.
And thank you, presenters. And ladies and gentlemen, this concludes today's webinar. Thank you very much for attending.